Good morning, everybody, and welcome to today's lecture. This morning, we'll be talking about offer and acceptance. And by the end of this lecture, we'll be able to define the key terms related to offer and acceptance. Now, to do a quick recap to last week's lecture. Last week, we covered the definition of contract and we listed the essential elements of a valid contract. Today, we'll be talking about offer and acceptance. Now, what is an offer? Simply put, an offer is a proposal made by one party, often referred to as the offeror, to another party, often referred to as the offeree, indicating intention to enter into a legally binding agreement under certain terms. It could be bilateral and it could be unilateral. For this, let us see the case of Carlyle versus Carbolic Smoke Ball. Now, a valid offer should have some essential elements. First of all, it must be clearly communicated. Secondly, the offer must be definite, must be certain, must be clear, must be unambiguous. Thirdly, the offer must be made with the intention of creating legal relations. Then next, the offer or the offeror must have legal capacity. That means they must have competence in the eyes of the law. Now we move to invitation to treat. There's often a confusion between offer and an invitation to treat. What is an invitation to treat? An invitation to treat is an expression of willingness to enter negotiations which will lead to conclusion of a contract. Simply put, it is just mere invitation to negotiate on the terms of a contract, and it is not legally binding. Here are some examples. Firstly, giving information, and we can see that in the case of Harvey versus Fassi, where Harvey inquired from Fassi about his property and inquired on the price of the property. Fassi replied and said his property was £900, and Harvey said he had accepted. At the end of the day, Harvey sued Fassi for performance, and the court held that the inquiry made by Harvey to Fassi, the information Fassi provided was not an offer, but was just a reply, was just giving information regarding his property. So therefore, it was Harvey that made an offer. And if Fassi had agreed to have Harvey's response, then there would have been a valid acceptance. Next, we move to display of goods. When we go to shops, for example, Tesco, and we see products displayed, they're just merely invitation to treat. Now, when we take those products to the till for payment, we're now making an offer to the store. It is when the till attendant accepts our money, that is when there is a valid acceptance. So it is in that situation that is a valid offer and an acceptance. And we can see that in the case of Fisher versus Bell. Next is the case of advertisements. When there's an advertisement made in a paper or a journal or an article for a sale of a product, they're just mere invitation to treat and shouldn't be confused as offers. And this we can see in the case of Partridge versus Crittenden. And next, we move to auctions. The whole exercise of an auction is just a mere invitation to treat and not an offer. However, it is when the highest bidder makes his highest bid, that is when they can be said to be an offer. And it is when the auctioneer's gavel falls or his auctioneer's hammer falls, that is when there's an acceptance. That is when they could be said to be an acceptance to that offer made by the highest bidder. Now we move to termination of offer. An offer can be terminated by various means. First of all, we have revocation by the offeror, and this can be seen in the case of Kane versus Cave. So An offer can be revoked by the offeror before it is accepted by the offeree. So that means the offeror needs to be proactive in revoking his offer. An offer can also be revoked by the offeror through a reliable third party. Let us bear that in mind. An offer can also be terminated through by lapse of time. So where there is a time or a deadline in the offer and the offeree accepts the offer outside that time, then it will be said to be out of time, which terminates that offer. Then it could also be terminated by a counter offer, which can be seen in the case of hide versus range. So when the offeror makes an offer and the offeree tries to modify or alters that offer or that proposal that was made, then it could be said to be countering that offer, that initial offer, which extinguishes, that's the implication, it extinguishes that initial offer and resets the clock. So it's like they're starting all over again. And now the offeree now becomes the offeror, and the offeror becomes the offeree. The next one is rejection by the offeree, which goes without saying. If the offeror makes an offer and the offeree rejects it ab initio, then it has extinguished the offer. Then there is death of either party when either of the party dies, or there is a breach of the condition of the offer when each of the party or either of the party breaches the condition of the offer. Next, we move to acceptance. And this is where the mirror rule comes in. Acceptance is the total agreement of the offeree to the terms of the offer, which can be seen in the case of hide versus range. When there's an offer by the offeror, the offeree is supposed or is meant to accept all the terms of the offer. If he tries to modify any of the terms, then that means he's not accepting, there's no acceptance to that offer in the first instance. Now, acceptance may be by express or implied action of the offeree. For example, if I say I'm selling my car for £1,000 and the offeree says, yes, I accept, either in writing or orally, then that is express means of acceptance. Or where if I say I'm selling my car for £1,000 and the offeree brings £1,000, that is acceptance by implication or by conduct. In lay terms, it is said that silence is golden, but in acceptance, silence usually does not count as acceptance, and that can be seen in the case of Feldhaus versus Bindley, unless the offeree begins acting as if they had accepted by conduct, like I said earlier. Now, for there to be an acceptance, the acceptance must be clearly communicated to the offeror. The acceptance must be unqualified and must mirror the terms. That means the exact terms that was provided in the proposal. And the acceptance must be made while the offer is still open. Offeree must demonstrate clear and unequivocal intention to accept. Now, we talk about the postal rule, which was established under the case of Adams versus Linsell. A postal acceptance becomes valid at the moment the letter is posted, not at the moment when the letter reaches the offeror. The only way to avoid this kind of situation is to add in the contract or in the offer that no contract until acceptance is received. And that can be seen in the case of Howell Securities versus Hughes. Nowadays, we have the more instantaneous means, which was established in the case of Enterprise Limited versus Miles, the email, the text messages, and the fax. Let us note that a contract can also be established outside the formal means of making a contract, which is also known as the collateral contract, which can be seen in the case of Shanklin Peer Limited versus Dettel. In summary, however, an offer is a statement of terms on which an offeror is willing to be bound. Acceptance is the act of agreeing to form a legally binding agreement based on an offer provided by the other party. An invitation to trade is not the same as an offer and it's not legally binding. Thank you very much for listening and have a nice day. Bye.